go live button, which means, as we know, we got to wait for those tubes to fire themselves up all across the fruited plain of the internets. Before we go ahead and get started, we got some serious business to attend to today. Woo! Man, it's going to be a show. We got Clavicle Girl. We got Big Fani getting WILLIS'd. It's going to be good today. All right, so we got some stuff. Let's make sure the tubes are connected. And it looks like they are. That is tremendous news. We're pressing some buttons over here on the locals to make sure it's going, and there it is. We can go ahead and get started, so let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Govea. I'm a criminal defense attorney, and today we're talking about Fani Willis from Georgia getting WILLIS'd by her special prosecutor called Nathan. And so, what a wild story this is. We're going to unpack it all. We've got a motion to dismiss that is brought by this guy called Michael A. Roman, and it is a doozy. We're going to go through it. We've already had some concerns about Fani, Big Fani from Georgia, and this guy, Nathan Wade. And we've covered this, months ago, because remember, Nathan Wade is actually a criminal defense attorney, or at least his office is. And so his office was sending notices to defendants that he was charging, saying, I can represent you, if you remember. And we were saying to ourselves, this is really weird. Why did she hire outside counsel when she has all of Fulton County to prosecute this case? And she went out and got this guy, these two little trial partners, Here she is indicting Trump. We didn't know that Nathan was giving her an old indictment himself. So we're going to go through all of this. It's just juicy as can be. The lawyer behind this is lawyer Ashley Merchant, and Mike Roman is going to be raising some funds to support these efforts. And so we'll pass that along as well. Questions are, did Wade commit a felony by billing 24 hours on a single day of work? This came over from our friend Technofog, saying that on one date, he billed 24 hours of time. And maybe in Georgia, that is illegal. Technofog is bringing that to our attention. We've also got a story that apparently he also met with White House counsel. You're kidding me. So he went over there, and remember, they were saying, oh no, there's no collusion at all between the White House and Big Fani. Turns out, there was travel to Athens to conference with the White House counsel. It's as corrupt as you can be. And these two apparently were going on cruise lines together. Okay, so what happened was Fani was paying for those services. Okay, he billed for this meeting for what the White House counsel, $2,000. And so she paid him, and then he put that money into a bank account, and then they went on a cruise together. Oh my gosh. So we're going to go through all of it. It's as corrupt as you could ever expect. And then keep Mike Roman at Mike Roman in your minds, because he's got a defense fund. So if you got any extra love to send their way, let's do it. Then we're going to turn our attention to Clavicle Girl, Cassidy Hutchinson. Oh, yeah. It turns out there was this notice of errata that got filed from her lawyers after she sat down for 4 depositions, 4 depos with the January 6th so-called investigators. And during that, there were 15 pages of errors, errata. There were mistakes, or you might call them lies, as we'll see. You can be the judge of that. But they had to correct a bunch of stuff that she said that was all not accurate. All right, let's just leave it there. You might call it lies. I think I would, but we're going to go through it and you can be the judge. So we'll see what happened there. Related to the January 6th stuff, Ray Epps also got sentenced today. And guess how much jail time he got? 0 days. Are you surprised? I'm not, because the whole thing was rigged from the beginning. Now, there wasn't something up, obviously I think that was unspoken. The judge looked at this and just gave him a sweetheart deal. We're going to read the actual order that came out from the judge. Ray Epps not going to see a single day in jail. Isn't that amazing? Even though, well, we'll leave that for the segment. So all that coming up. And then Trump was celebrating. We had a big day in the D.C. Circuit Court of Appeals. All of these judges were listening to these oral arguments. And you can just take a look at, the judges and basically draw your own conclusions on it. But we're going to learn more about him. Our friend Julie Kelly posted an update on who this judge is. Judge Florence Pan. Got an update on her. Some journos were out there. Donald Trump made his way into the courthouse. The courthouse was apparently filled with journalists who were talking about assassinating Donald Trump, which was insane. And so we'll hear that. I've got some other clips from the actual immunity debate. So Trump's team, of course, is there saying the president has immunity, can't be charged. The president has already been charged. He's got double jeopardy. The president cannot be prosecuted by Jack Smith. That was taking place. And so I've got a bunch of clips of that, about, I think, 4 different clips. All of the judges going after John Sauer, who is Donald Trump's defense lawyer. And we have a nice rebuttal from him as well. The judge is asking him kind of crazy questions like, well, what happens if Trump uses SEAL Team 6 to go and just execute his political opponents and all that type of stuff? And so we'll see what they all have to say about it. And then Trump was also there, and he came out and had a bit of an update as well, saying, look, our team did very good today, and I've done nothing wrong. I'm the victim of political prosecution, which of course is all true. So we've got 3 segments today to get into. We've got immunity stuff to talk about, Cassidy Hutchinson, Clavicle Girl, little Ray Epps update. We've got Fani getting WILLIS'd by Wade. So we're going to talk about all of that and more. And then as per usual, we're going to go over to watchingthewatchers.locals.com for our members only after party and take a look at what our membos have to say as we debrief the show. We have an amazing community. We really try to deliver for our members. We do member streams in the morning. We do Saturday streams. We already had a full stream this morning before this show started, talking about all sorts of other stuff. This Lloyd Austin situation is bizarre. Mayorkas was down at the border, talking about all sorts of the other affairs happening out there in the world. And so if you want to come and join us, get some extra content, but really connect with an extra community, extra special. Come and join us, watchingthewatchers.locals.com. And if you join us as a member on YouTube, you get all the same stuff, except on the after party, you got to join us on Telegram. So go to the community tab section on YouTube, navigate down to the post section, find a private post only for members, and that's where you'll find the Telegram group. We also have our website, robertgovea.com. Something you can do if you want to help the show is sign up for our daily newsletter and then forward the emails that you get to everybody you've ever met or known. That way they know what's going on here and they can see all of this egregiousness out there that is happening in our country. And so robertgovea.com is the website, watchingthewatchers.locals.com, members only after party. And so let's get into it, my friends, because man, this is juicy and we got to get to it. Fani got WILLIS'd by her own Wade, the special prosecutor in Georgia. This is a motion that was filed by Michael A. Roman, this guy, former Trump special assistant who's been charged by Fani Willis in Georgia as part of her RICO case. And so we've been following this case. We know that Sidney Powell took a plea, Jenna Ellis took a plea, all for diversion deals, so there will not be any convictions associated with those when their charges are dismissed. But Mike Roman not taking a plea deal. In fact, he's coming out swinging hot, and he's filing a motion to dismiss all of Fani's cases because of this impropriety, which involves her, Fani Willis, and Nathan Wade, the special prosecutor that she went out and appointed. We've had a lot of questions about Nathan Wade for some time because his office was sending notices to people that Fani had charged saying, I can represent you as a defense lawyer, because his office is a defense firm. So he was sending people that he was prosecuting notices saying, I can also defend you. And so there was a big hubbub about this in the courts. They said, this is ridiculous. Why are you harassing our defense clients and so on? And the judge just said, well, it's kind of, no harm, no foul type of situation. So we've been asking about this because he's been billing big numbers to her, and she's got an entire office. Hello, she's the DA of Fulton County. She's got 100 other prosecutors that she could assign to this, but she went and got this guy, who we learned was her mentor. Much more than that, as we'll see. And they were sitting there in court. Look at these two. Oh, just cozy as can be behind the government table. Yeah, just prosecuting all their political opponents. Got it. So we're going to go through the motion and then ask ourselves, did Nathan Wade commit a felony? Was Fani Willis conspiring with him to commit a felony? Should she be charged with a RICO of her own? We'll go through all of it all. And then Mike Roman, of course, could use your help if you've got some extra funds. He is raising funds for his defense, and we know that he'll need it. So we go right to the motion, and it is juicy. Filed by Michael A. Roman, state of Georgia, Fulton County, Big Fani's jurisdiction. He says the following. Now, defendant Michael Roman is here moving to dismiss this entire case, calling it fatally defective and saying he's got a motion to disqualify Fani, her office, and Nathan Wade from any further involvement in this manner. Whew. Now comes now Michael Roman, they say, and he's here under the Constitution saying that Georgia has done a bunch of bad things here and hereby moves this court for an order striking the special purpose grand jury that Fani orchestrated and dismiss the criminal indictment in its entirety. Why? Mr. Roman grounds that this entire prosecution brought by Fani is invalid and unconstitutional because Fani never had legal authority to appoint Nathan Wade, who assisted in obtaining the indictments. Now, as a result, both indictments contain structural errors, irreparable defects, and should be gone. We also move this court for an order disqualifying Fani, her office, and Nathan from any further prosecution because why? Fani Willis and Nathan Wade have been engaged in an improper, clandestine, personal relationship. They were indicting each other, it sounds like, during the pendency of this case, which has resulted in the special prosecutor and in turn Fani profiting significantly from the Trump prosecution at the expense of the taxpayers. Whew. Now, accordingly, the DA and Nathan, Fani, have violated laws about the use of public money. They've got irreparable conflicts of interest, and they have violated their oaths of office, and therefore they should be disqualified from this case. Now, here is where they start. The instant motion is not filed lightly, Judge McAfee, nor is it being filed without considerable forethought, research, or investigation. Nonetheless, this motion must be heard, as the issues raised herein strike at the heart of fairness in our justice system, and if left unaddressed and unchecked, they threaten to taint the entire prosecution, to invite error, and to completely undermine public confidence in the eventual outcome of this proceeding. Saying there are fewer positions of authority in Georgia's justice system more powerful than elected district attorney. And we make this point here repeatedly. This is why we call her Big Fani Willis, because she is the biggest DA in Fulton County, which is a huge county, the biggest one in Georgia, making her the biggest DA. That's why we call her Big Fani. The district attorney has incredible control and influence over the entire process, including the power to decide who and when to charge and how to charge them, what cases will get tried, which cases will be resolved, and importantly, Fani has the power to allocate public monies for the operation of the office. Now, historically, there have been few checks on this power in Georgia, and DAs have largely been able to have broad discretion when making their decisions. But this case with Fani and Wade presents a unique opportunity for this court to review this authority to determine whether Fani overstepped her authority, whether the special prosecutor Wade violated the law, and their obligations together under the rules of professional conduct when they indicted each other in a personal, romantic relationship, which has ultimately yielded substantial income to Wade. He's getting paid too. Who is this guy? The important issues raised in the instant motion suggest that the elected district attorney for the largest DA's office in the state of Georgia, confirmed in court filings, the biggest Fani, has used the instant prosecution to pay her partner a large sum of money that was originally allotted to clear the backlog of cases for COVID. Now, normally, the DA's use of funds allotted pursuant to the county's prior approval would not be newsworthy or legally actionable, right? She can move her money around. That's why she got elected. It's a nice gig if you can get it. But this case is different. Fani sought additional funds from Fulton County to clear out the COVID cases, and she made a detailed presentation to the board. She actually got the money. She's like, I need help or some more money. But she has not used those funds for that purpose at all. No. In fact, she used those funds to prosecute this case. Now, even assuming that were proper and could be forgiven, she just reallocated some stuff. This is more important. I have the discretion to decide, okay. There is a separate and very important concern about her using this money. And as the layers unfold, it becomes clear that Big Fani and Nathan Wade, they've been prosecuting personally from this prosecution at Fulton County's expense. Now, instead of handling this case within her office, as she could have done using the COVID money within her office, right? She could have prosecuted this here. She chose to hire a special prosecutor who's a private attorney to reign over the case. And we were like, who is this dude? Now, once again, on its face, this is not earth-shattering, generally within her discretion, but there's several important facts that distinguish this case. Now, before they appointed Nathan Wade, they were required to get Fulton County's approval prior to bringing this guy in, because she's already got a bunch of prosecutors. So why do you need to go find someone else? Now, the reason for this is simple. It ensures the DA, like Fani, cannot unilaterally act with regard to public monies and control where the money goes. The public needs to have confidence. Now, undersigned counsel, the lawyer, says, I have found no evidence that the DA sought or ever received any approval from this to appoint a special prosecutor in Fulton. She just did it. Now, this is not a mere technicality. It's a requirement that the Georgia Supreme Court has said must be followed when we get a special prosecutor, and therefore it is a requirement in this case. Now, since the DA, Fani, was fully capable of getting this permission, then it is clear she knows how to do that because she went and did it to get the COVID money. So she's done this before. So that begs the question, why did Fani not do so to go get Nathan Wade? Now, one could assume it was oversight, but digging deeper, the potential reason becomes obvious. As has been pointed out in prior filings, the special prosecutor's oath of office was never filed. Nathan never submitted it. Now, that might have been an oversight. It may also have been purposeful, a specific attempt to shield from public knowledge the fact that Nathan Wade had, in fact, been appointed without legal authority. It's incredible. Also, Jack Smith is illegitimate, according to a former AG. They are bringing in people outside of the normal justice program, and as we can see, they're corrupt as can be. Now, perhaps more important and enlightening, however, is the identity and qualifications of the specific person that she chose to lead this. Saying that Fani chose to appoint her romantic partner, who at all times relevant to this prosecution has been a married man. Woo! Not good. Not good at all. Now, of course, these are all allegations. Fani's going to have an opportunity to respond, and so is Nathan Wade. Now, we'll see if they have an explanation for this. But right now, it sounds like they were motioning on each other. You know what I mean? So, admittedly, this is a bold allegation. Yeah, you better believe that. Considering it is directed to one of the most powerful people in the state of Georgia, Fulton County DA. But nevertheless, the DA's fame and power, they do not change the fact that she decided to appoint a special prosecutor with whom she had a personal relationship, who's now leading the prosecution. No one's above the law, especially the conflict of interest laws. Now, even assuming this type of nepotism might be forgiven, because we're like, oh, whatever, they love each other, Rob. You can't fight love. A review of the amount of money that Nathan Wade has been paid and the personal activities of the DA and Nathan Wade during this shed light on just how self-serving this arrangement has really been. So the court may well be wondering, this is great, now for good reason, Madam Ashley, the lawyer who's filing this, how do you know this? And why does it matter? Okay, a lot of people, well, so what if they're in love, Rob? Open records request of Fulton County on the answer of how we know this revealed that DA Fani did not obtain county approval. No records showing she did. Why would she not do this prior to appointing Wade? Wade admitted his oath was not filed prior to his work. How come? Why would the special prosecutor not just file the oath? You know, he's got an office. They can just file simple administrative tasks any day, right? The special prosecutor is also, this is Wade, seeking a divorce in Cobb County. And he sought to successfully seal those records, hiding them from public view. Now, why would a private citizen like the special prosecutor shield his filings related to his income and his spending from public view? Interesting. Now, while the filings in the divorce case are sealed, and the legality of the sealing of that, which is open to question, And I'm not a family law lawyer and really detest that practice of law. And hats off to the family law practitioners out there. You guys, I don't know how you do it. But I don't know if this is a common thing, sealing these records or not, if this is a common thing in Georgia, whether they did it lawfully or legally. This attorney says, no, we're questioning the legality of it. Now, information obtained outside of court filings indicate that the DA and the special prosecutor have traveled personally together. These must be legal trips for legal research. We have to consult our books. Where'd they go? Napa Valley, Florida. They went to the Caribbean. And the special prosecutor, that's Nathan Wade, he purchased tickets for both of them to go on the Norwegian and the Royal Caribbean cruise lines. Oh, that sounds beautiful. I wonder if they saw the Northern Lights up in Norway. How pretty. Hey, baby, this is so beautiful. Now, traveling together like Washington, D.C. or New York, that might make sense because they're going to work on litigation. But why are they going to the Royal Caribbean and to these usual traditional vacation destinations? Now, the DA, Fani, and Nathan Wade, they've also, been seen together in private in and about the Atlanta area. And I wonder if they've got someone snapping photos of them, like a private investigator or something. I would not put it past these attorneys. In other words, they know that Fani's going to issue a reply and say, this is our prayer, right? And then they're going to say, no, here's the second order, right? We've got another litany of stuff that we'll drop on you. So they also believe to have cohabitated in some form or fashion at a location owned by neither of them. Seedy motels that nobody can keep track of. Very curious. Now, sources close to both Nathan and Fani, they've confirmed they've got an ongoing personal relationship during the pendency of Wade's divorce proceedings. Now, according to these sources, the personal relationship between Fani and Nathan began before this prosecution was initiated and before the DA appointed the special prosecutor. So they were indicting each other, and then she's like, man, you're a really good indicter. You want to indict someone else? So undersigned counsel knows that the special prosecutor knows the special prosecutor, knows Nathan Wade, because she's also a defense attorney, just like he is, and has researched his litigation experience. Who is this guy? That research reveals that Nathan Wade has never tried a felony RICO case. Never, not once. Yeah, because he's a defense lawyer. The state of Georgia and the city of Atlanta have several lawyers who specialize in these cases. Now, despite having access to these resources, why would the DA appoint someone who's never even tried a RICO case, as is evident by this? And by the way, we were way out ahead on calling this case garbage as soon as we saw all of the plea deals that came through, which lead to no criminal convictions for anybody. So Sidney Powell, Jenna Ellis, Kenneth Chesebro, Scott Hall. Yes, they took guilty pleas, but they were held in abeyance and their charges are going to be dismissed. And we were wondering, this is crazy. This was supposed to be the worst crime against America since the Civil War, all this stuff, right? They have no case. These people are incompetent to boot. Not only is the case bad, they're incompetent and corrupt. Never even dealt with this before. It's a complicated thing. Saying Nathan Wade, based on his lack of experience in this type of felony, would not be qualified under Fulton County standards. If the special prosecutor was not qualified to defend this case, then how can he be qualified to prosecute it? Right? And so if you're a public defender, there are different standards. You got to have certain experience. Like if you want to, like if you're a first year public defender, they don't say, here's a murder trial. Right? You have to second chair a murder trial with somebody who's already done one. And then you get a certain amount of, credentials essentially before they appoint you. So here, if he never would have even been qualified to defend this case, how can he prosecute it? And since being appointed the special prosecutor, he's been billing, and a lot, $1 million in legal fees. That's good money. Now, of course, additional fees would be expected, but that would assume they're not in a relationship with the DA. And the fees have been very lucrative by comparison. The DA's yearly salary from Fani, including state and county supplements, is just under $200 grand. The total annual budget for the DA's office was $31 million. And so the DA got additional money that she lobbied for. So why didn't she use that money to hire in-house staff to try the case? Why did she give it over to Nathan Wade? The reason this is important, she says, is because the DA, Fani, her failure to get approval to appoint this makes all of these indictments means that Nathan Wade is not qualified. He doesn't have the power to actually do what he did. And so that everything that he got is now a nullity and it has no effect under Georgia law. And so everything must be dismissed. Now, in light of the DA's personal relationship to the special prosecutor, his appointment created an irreparable conflict of interest that violates the rules of professional conduct. And that requires both lawyers got to get off the case. Saying the DA, Fani, her apparent intentional failure to disclose her conflict of interest combined with her own decision to actually hire this dude based on her own personal interest, well, may be an act to defraud the public. Like it's a crime. Why? Because she personally benefited from the disclosed conflict of interest. She was going to Norway, man. She was roaming around the Caribbean, which is a crime under the U.S. Code 18 Section 1346. It's a predicate act that could also be a RICO charge against Fani. Woo! Who was involved in this? Who else was colluding with this? We want to know. Now, putting aside both the legal and ethical implications of their conduct, it also undermines the sanctity of the justice system. It erodes the public trust, and it would place them above the law. We know no one's above the law. So to allow this conduct to go unchecked by a powerful elected official threatens to undermine the very principles of democracy that she claims to defend in this prosecution itself. It seems hard to believe that such a powerful person like Fani could escape scrutiny and accountability for such egregious conduct simply because she believes that she maintains the moral high ground and holds one of the most powerful positions in Georgia. Now, this is particularly true since she has used that platform and megaphone it provides to tour the country, giving interviews in her pursuit of a conviction. She's like a public figure now, right? Like a mascot for prosecuting Trump. Now, it is for these reasons and other important reasons that we're filing these motions. The actions of Fani and Wade are indefensible under our laws and have created a fatal and irreparable defect against our client, Mr. Roman. To allow either of them to stand above the law would be inviting others to do it. And so this case must be dismissed immediately. And these two must be recused and disqualified from further activities. Now, here's the factual background as we zoom in. Saying, upon information and belief and based on discussion with individuals with knowledge, Willis and Wade, the lovebirds, were romantically involved prior to Willis giving him the deal. She's like, well, I got to give this to somebody. How about I just funnel $1 million to you, baby? It's not entirely clear when the relationship began, but Wade was married. Maybe this is the cause of the divorce. I don't know. Now, on November 2nd, a day after his first contract with Willis, Wade filed for divorce. Wow, that's shady, isn't it? So she's like, look, here's the deal. I'll give you this big fat contract. It's gonna be like $1 million. Wade says, that's really lucrative. My wife is terrible. She sucks. So he's like, okay, you're out of here. Old and busted, new and hot. He's like, Willis has got my back, baby. She's my sugar mama. She's going to be funding the rest of my life through this illegal contract. Wade then had the divorce proceedings sealed in February. Now, while the filings in the divorce case are sealed by court order, undersigned counsel has learned that Willis and Wade, and you want to see what's inside. Like, what did she say the reason for the divorce was? Or what did he say? What was the response? They traveled personally together to Napa Valley, to California, to Florida, to the Caribbean, and Nathan Wade, he purchased tickets for both of them to travel on the Norwegian and the Royal Caribbean cruise lines. Now, Wade has also purchased hotel rooms for personal trips, look at this, with funds from the same account that he got his money from Fani. So he sends Fani a bill. He's like, hey, baby, you want to go on a cruise? She's like, yeah. He's like, but I can't afford it. He's like, well, hold on a second. Let me send you a bill for all the legal work that I did. Sends her a bill. Her people approve it. He gets $1,000 right into the same account. He goes into that same account, dips into that, and then buys cruises and hotels. Amazing. Now, the order out of the divorce was signed as a consent order, sealing the record. But the required hearing was not held prior to the order being entered. They just did it. So therefore, the order is void and it should be unsealed. However, without knowing the record had been sealed and prior to the court clerk actually sealing the record, this lawyer was able to view this record and to obtain copies of certain documents that had been filed upon review of the file at the clerk's office. Now that the record is sealed, undersigned counsel is seeking to have those records also unsealed and will not discuss the contents of the sealed records in this public pleading until either the records are unsealed or this court conducts another proceeding under seal so that this lawyer can share said proceedings and information under seal. Whoa! So this attorney has the goods, okay? So she went, viewed a bunch of stuff, but it is sealed now, and she is just doing the responsible thing. You know, this feels like it's like a lot of airing out of the dirty laundry, but this lawyer is being actually reserved. Like, look, I saw a bunch of stuff. It's not public. It's probably, pretty juicy. And so I'm just sharing, and essentially I'm just sharing with you what I have to share with you to get you to do something about this. And the rest of it, they're holding in reserve. So in addition, DA Fani and Wade, they have been seen in private together in a personal relationship capacity in and about the Atlanta area, and they believe to have cohabitated in some form or fashion at a location that neither one of them owns. Yeah, we know what those locations are. Now, sources close to both the special prosecutor and DA Fani have confirmed that they've had an ongoing personal and romantic relationship during the divorce proceedings of Wade. Homewrecker, man. So we also know that I think Fani told us originally when people were asking questions about this that he was her mentor, right? Like at law school or something like that. Let's see. Now they say there's no evidence that Fani was authorized to use these funds to hire Wade. In fact, in July 2021, Willis went to the board to get COVID money. And she told the board that it was in a crisis. And so the board gave her money. And we've confirmed that Willis knows how to do this. Okay, she got the money. She knows how to do it. She goes to the board. I need money. They say, okay, here you go. But we know through records requests and other direct inquiries that Willis did not go through that process. Co-defendants counsel also spoke with Fulton County Commissioner who verified Willis never got approval for Wade to be appointed or paid. So where's that money? What's she doing with that? That money's just being like repurposed over to her Wade. Now, in addition, undersigned counsel has been unable to find any evidence that Willis has ever disclosed the personal nature of her relationship to Wade, to the BOC, the board, prior to contracting with Wade as a special prosecutor. So he didn't file any oath as required under the law. The loyalty oath was not filed until September 27th, just a few months ago, after Wade had already appeared and participated in a bunch of stuff. And so he did not file his oath of office. And so therefore, he is not valid, not under a valid employment contract with Willis, just not valid. Now, despite this, Wade signed numerous subpoenas as a special prosecutor. He used the power of the state to command appearance. Wade obtained orders to compel attendance of out-of-state witnesses, other people who were asserting privilege and immunity. He negotiated immunity deals and all this stuff. Now, he said he was a duly authorized special prosecutor, but he wasn't. We know that he's also somebody who has no experience. Willis contracted with Wade to be a special prosecutor. He's a private law firm doing hourly work. Now, based on the personal knowledge of Wade, an undersigned counsel is aware of, so she knows him from practicing with him. We are unable to find any history of Wade ever having prosecuted a single felony trial. All right. Not even a RICO case, but not even a single felony trial, much less at the rate Willis is paying him. So he's like a brand new first-year prosecutor. Now, based on his current experience and based on his current appointment guidelines, Mr. Wade would not be qualified to serve as defense counsel in this RICO case. Why? He has not tried at least 2 criminal trials of similar offenses. In addition, even if he was a public defender, he'd be getting $140 an hour, not $250 or whatever he's billing at. Now, his initial contract with Willis commenced in November 2021, and the only copy of this contract is a copy of an addendum that was not signed until March 1st. Wade was also going to be reimbursed for a bunch of money. Now, one day after the initial contract commenced, Wade filed his complaint for divorce. Now, it's apparently, she says, apparently Willis and Wade had already begun a personal romantic relationship with each other. Willis's initial contract with Wade does not identify any hourly rate about what he was supposed to be paid, but during this year-long period, however, Wade got $300,000 and $3,500 for travel. 1 year, $300,000 a year. That's $100,000 more than Fani's making. Wade's invoices for his services in connection with the case were broken down as follows. Here, right, every month, $15,000. November, 15. December, $15,000. $15,000. That's interesting. It's all the same number. It's like, he's like, that's weird. He's billing hourly. It's the same hours every month, or is that the retainer? And then he's making adjustments for it. Well, I don't know. So February 22, $9,000. Whoa, March was expensive. $32,000, $33,000. Those are good months. $33,000 here, $34,000, $34,000, same, $35,000, $35,000. Now, the first 3 invoices were paid out of the confiscated funds and seized property fund. So Fani's just like taking all that money from so-called criminals and then giving it to her, Wade. Now, the second contract between Willis and Wade, she's like, man, you're doing a great job. I want to re-up you. Let's go on another cruise again, honey. Provided payment for Wade at $250 per hour, 600 hours cap, $150,000 during this contract period. That was signed later, and Wade got $173,000 out of that. So more money than he was supposed to. All the invoices are attached. Now, based on the documents, it appears that Willis and Wade did not have an executed contract at any time, while Wade was involved with presenting the case to the grand jury. So more invoices. December 22, November 22, $25,000, $23,000. You can see big numbers, $20,000, $34,000, $36,000, $35,000. A third contract also came in. That's for $212,000. Wade got over $500,000 for his work with the, quote, anti-corruption unit. Now, they also say Wade's law partner, Chris Campbell, also entered into agreements with WILLIS'd to provide legal services. He was also tasked with other things. Campbell also got a bunch of money. Now, Wade is a partner at Wade and Campbell Law Firm, and a recent mailer indicated that they're advertising as law partners. Yeah, and we also saw that they sent a solicitation to a defendant from one of those entities. But there's no corporations registered here, but there are separate. So she's looking into his, LLCs and what he's done here. But total, a lot of money. There is no contract for May 15th to June 12th on file. But if the prior amounts hold true, Wade's total compensation under the contract's likely to amount to more than $1 million. $1 million. Not bad. Now, the billing to date does not include the amount paid to his partners as well. Here it says Willis, she just got $129,000. It's just not fair. Down with the patriarchy, Says here, she was forced to pay him all this money. The patriarchy's so bad. The Judicial Council of Georgia recently recommended to the Supreme Court justices that they get an increase. So the Supreme Court justices are also making $223,000 a year. But Wade's getting a lot more than that. And what's fun is Wade's income has been used to travel with Willis to vacation destinations, and they've even brought their family with them too, because they got to make sure their kids get along. Now, Wade's former partner, Terrence Bradley, also entered into agreements with Willis to provide legal services. And so she's just, dishing out funds to her cronies. Prior to Bradley and Wade, they dissolved their law firm. Bradley got 74 grand. Then after dissolving their association, Bradley no longer got any money from them. So they say, all that being said, this indictment is now void. Why? Georgia law says you got to be able to appoint somebody appropriately. Yes, she has discretion, but she has not recused herself from this prosecution. And the law says if you've got a potential conflict of interest, you got to do that. The statute says you also got to go to the board and get permission before you hire somebody. But if you apply these principles here, no, she didn't do any of this. The indictment must be dismissed. Why? Wade had no legal authority to act since Willis never got a permission to even contract with the guy. It appears evident that Willis did not obtain prior approval to even have him as a special prosecutor. There's no documentation. There's no other evidence in the public records that show anything was approved for Wade. And Fulton County indicated that no records exist. And so Willis also did not obtain their board approval because he was outside counsel. Saying since Willis knew how to obtain this permission, she didn't. Why? Placed in the context of her actions as outlined here, the answer is obvious. She knew the board would ask her about her relationship with Wade. She knew they would ask about his experience. Both questions she did not want to answer. Now, with her power as the DA, perhaps she thought no one would notice or no one would care, or she would ask for forgiveness. In any event, she acted without lawful governing authority. And since Willis never had any authority from Fulton County to contract with Wade, Wade in kind has no authority to investigate this case or to ever seek an indictment. Therefore, this indictment is fatally defective and it must be dismissed. Wade also never submitted his oath of office. He signed a bunch of subpoenas. And he says, now, Mr. Roman understands that this issue was raised by other defendants in prior filings. And this is another particular argument. Okay, the oath of office. So that came up. We'll fast forward through that. The judge said, I heard the oath of office thing. That's okay. They fixed it. It was a clerical thing. This is much bigger. Now, Mr. Roman reasserts this oath of office thing because it's got a bunch of new facts here. The oath was not just a clerical error. It was a cover-up attempt. So please reconsider it. Saying in this case, Wade was not a member of the DA staff, was not sworn and duly authorized. He was present because Willis alone had authorized him to be present, but he had no legal authority to actually do any of this. Willis had to follow the law. Wade, therefore, was a mere spectator. But he participated and he influenced the grand jury. And so you got to go. There are sound reasons why all prosecutors must be sworn and authorized, because they have to minister justice. Yeah, right. And not simply that of an advocate. They swear an oath, right? Higher standards, so-called. But in practice, that's not true at all. They say Wade asserted these same powers. He was acting as a prosecutor. He was using prosecutorial powers. And so Roman is charged with conspiracy to commit impersonating a public officer, right? Roman, they said, you are impersonating a public officer, which is exactly what Wade is doing. It could be argued that Willis conspired with Wade to falsely hold Wade out as the duly appointed special prosecutor and misled witnesses, misled grand jurors, misled court staff, and even defense counsel. It could be further argued they did it for pecuniary gain and that Wade got paid from taxpayer funds. So what they're charging him with is literally what Fani has done. Saying same thing with count 11. They're saying that Mr. Roman committed forgery and fraud. Well, it could be argued that Willis conspired with Wade to defraud Wade's oath of office and all of the checks that were made out and delivered to the clerk. And they could say that they did it for pecuniary gain. Now, we also know that they had a romantic relationship. You're supposed to be prosecuted by a disinterested prosecutor. And prosecutors can be disqualified if they're not impartial. Now, Willis and Wade are operating under a conflict of interest, and so they should be disqualified. Willis breached her duties. She violated her oath of office. In her oath, she says that she'll prosecute people impartially, without fear, favor, or affection, unless it's with Nathan. So help me God. Well, she violated that. Willis has benefited substantially from this. He's paid hundreds of thousands of dollars to prosecute this case for her, and then he turns around and takes her on vacations. All of it paid and authorized solely by Willis, her own little slush fund. Now, this has happened even though Willis has not sought or got any permission to do this. She's got a bunch of prosecutors who have salaries, who with more experience, who could have prosecuted this case. But instead, on the day before Wade filed for divorce, she entered into an agreement with Wade far above what anyone else was being paid. Wade was the single biggest expenditure for her office in 2 years, 2022 and 2023. Cost the most amount of money for Fani. Now, based on the foregoing, they say Willis and Wade should be disqualified, and their offices got to go too. The rules of professional conduct merit as much. Saying Fulton County Code of Laws also declare that this is a problem. Any conflicts of interest must be brought out. It prohibits an officer like Willis from indirectly receiving a gift or anything of value, like a cruise. Here it's clear that she violated Fulton County laws, and she got herself right into the middle of a conflict of interest. She gave Wade lucrative contracts, and it shatters the public integrity and the faith in her prosecution, causing an irreparable conflict of interest for her and undermining the confidence and the ability to bring this case to justice. Now, the meaning of all of this is simple. They say Willis violated her own county's ethical standards, was involved in a conflict of interest, had a personal and financial interest in this appointment, never disclosed her relationship, and never even got their permission. As the Fulton County laws make clear, under those circumstances, there was a conflict of interest. She should have promptly submitted a written letter. She did not make any proper disclosures. And based on this, we now respect that their firms be disqualified. Bunch more statutory rules here saying, look at all these. She violated those rules, violated those rules. Those are the rules. And here, they both violated these. And it violates Mr. Roman's right to a fair trial. Both have acquired a financial interest in Roman's conviction. Wade has personally and financially benefited from his relationship with Willis. He gets paid $1 million. He's then going to continue to prosecute this case based on his financial motives. Oh, we're definitely going to trial on that. I'm billing $250 an hour. So probably more than that for trial. We'll see. So he has acquired a unique and personal interest in the continued prosecution, and he's going to keep going as long as possible. Willis has also created a system where she gets personal benefits. While she's not paying herself directly, she's just laundering the money through Wade, and then he takes her on cruises. Now, it says it's worth noting, though not the focus of the motion, that Willis has been on national media outlets discussing this case. If it continues, Mr. Roman's going to have no choice but to file a motion to prevent her from making statements. There's no doubt that some of her statements are designed to condemn Mr. Roman before the trial begins. And she's trying to poison the jury pool. But Fani is not directly paying herself, but nonetheless reaps the rewards after Wade gets that money. And both suffer and labor under conflicts of interest that you cannot deny now. And so, due to the receipt of their county money, Wade also have a proprietary interest in the prosecution, and they're all benefiting in violation of the rules. Now, Willis, as we near the end of this, is also someone who may have violated RICO and U.S. Code. Willis failed to disclose her conflict of interest. Honest services fraud is a crime under federal law. Includes public sector honest service fraud when public officials fail to disclose a conflict of interest. We could also get her under RICO. Now, as such, 2 direct deposits and 2 mailed checks into Wade's account are 2 transmissions in the execution of honest services fraud that confirm a pattern of racketeering activity. Now, the irony that Willis and Wade engaged in a pattern of racketeering that could be charged as a federal RICO case is not lost here. Indeed, prosecutors have highly favored using this law, much like Georgia, because it's vague enough to be applied to corrupt public officials. Now, if government officials makes an official decision, then that office has been defrauded. And as explained in these cases, this is why it's a problem for Fani. Now, it is not our intention here to find ways to prosecute the prosecutor, but it must be brought to the attention of the court that the actions of the two lead DAs in this case, arguably, what they've done arguably constitutes crimes under federal law. Judge. And so for the foregoing reasons, Mr. Roman respectfully requests that this honorable court grant the instant motions, dismiss the indictment against Mr. Roman, disqualify Willis and Wade and their offices from proceeding in this any further, signed by Ashley Merchant, Georgia. So, great filing, lot of juiciness here. Now, let me poke around and show you what else is in this document. We're taking a look at the exhibits. Fulton County DA's office, Fani Willis, looks like a slideshow presentation. 584 murder defendants indicted, right? That's a nice slideshow. We've got some other documents here. And so let's just fast forward. What we're looking for are filings of billings. Okay, we scroll down, the great trifecta, COVID backlog. Okay, she's presenting all of this saying, I need more money. And they say, no problem. We're going to give you a bunch more money. Okay, district sources, all her PowerPoint slides. Give us more money. Thank you. They gave her a bunch of money, right? So she knows how to do this. Here, this is a resolution authorizing Fulton County to do some things. And we've got more documents. Here are some contract assignments, professional services documents. Here are some invoices. Oh, so here's what Wade is sending in. Invoice number 1. Law offices of Nathan Wade, the anti-corruption special prosecutor who's taken his corrupt DA on cruises. Prepared cases for pretrial. Meeting with the unit, 4 hours, $1,000. Look at this one. Prepared cases for pretrial on 11/5. Man, this dude pulled an all-nighter, didn't he? 24 hours at $250, a $6,000 day, which is incredible. So he literally worked and billed every single stinking minute. He didn't go pee-pee, not even once, for 24 hours. That's curious. That doesn't seem possible, does it? So what we notice there is that is fraudulent billing. And you know who caught that one? Our friend Technofog. Here's what Technofog nailed for us. He says, Fulton County Special Prosecutor Nathan Wade is like Superman. He can just work all the time. He is alleged to have been having an affair, but now apparently he also worked 24 hours on January 5th straight. Well, January 5th, that was an important day in history. The day before January 6th. And that was 2021. So that none of that had happened yet. I'm sorry, January 5th, 2021. Is that right? Yeah, it was. Oh, 11/5. Okay. 11/5. It's 11/5, 2021. So this violates Georgia false statements. That is a felony. Okay, so our friend Technofog is pointing this out. Under Georgia law, anyone who makes a false or fraudulent statement or makes any false writing, including of a state agency or government, is liable for a felony, according to Technofog. And so, my goodness, you see it right there in writing, a criminal violation from Nathan Wade. Now, what's also interesting, you see some of these other invoices. That's 15 grand right there. Case summaries, $2,000. Read and review case summaries, 8 hours, $250. So he's reading all day. This guy's just like a rounding. 8 hours. I woke up, had a cup of coffee, and I read and I reviewed case summaries for 8 hours. Good day. $2,000. And just bills her. Now, a lot of this stuff, okay, more meetings, discuss Georgia, 15 grand on that one. All of these various different 15 grands And you can just see a lot of money, lot of different invoices. But there was one in particular that stood out, $32,000 on that one. That's pretty expensive. But in one of these invoices, we see that there are travels for out-of-state interviews. And they're meeting with certain people all over the place. Witness interviews, South Georgia, drafting and researching stuff. Here, Uber and public transportation, Delta Airlines, flying to the Hyatt. Thirsty Lion Gastropub. They're eating smash burger there. So, having some hamburgers and so on. But all of this keeps going. Hank's Oyster Bars, right? Likes oysters. Got it. Now, in one of these meetings, take a look at this. This one is invoice number 8, and it is from the May time period of 2022. So the team meetings, he bills $4,000 for that. 2 days, 2 full 8-hour days. Then he's got a strategic plan, meeting with the judge, investigation, witnesses, and interviews. Then he's meeting with opposing counsel about some testimony. And then look at this. He travels to Athens on May 23rd, 2022, and he has a conference with White House counsel. See that? A conference with White House counsel. That's Joe Biden, right? You mean the Joe Biden White House? Huh. That's strange. Because they told us that there was no conversations between Fani's office and the White House. No, she said this multiple times. I bring my own cases. I do what I want. I don't call anybody. Like, we've played her multiple times saying that. I take no instruction. I have no idea what they're doing. No idea. Obviously, they're meeting with them. So they actually had a full conference with the White House, and it wasn't a short phone call. It was 8 hours at $2,000, 8 hours with the White House counsel, orchestrating this whole damn thing. So also motions and right, and that's what he just billed in there. Now, due to billing restrictions, this invoice has been significantly truncated. Okay, so in other words, I have a lot more that I would say about what I did, but I can't tell you here because it's all secret and whatever. So he has a conference with White House counsel, and apparently they landed in Athens, like they went over to Athens to go hang out with him and to collude and to conspire to take out their actual opponent, which of course they are doing right now. So you can see they're about as corrupt as it gets. Everything that we thought about them is true. We knew for a long time that they were incompetent, didn't realize they were this corrupt as well. Now, they'll respond. We'll see what Fani says about this. We'll see what Nathan Wade says about this, but it's in the documents, right? And I think the defense team has made a nice presentation on this. And my guess is they've got receipts. All right, here's Fani and Nathan signing off on this document, renewing their contract. And you see some of the billable hours, 50 hours a month here, 100 hours in January, 150 grand on that, 600 hours total, 250 per hour for her cruise partner. And here's another set of bills. Now, here's another one, an interview with DC and the White House. That's interesting. Another one. Look at this one, invoice number 14. So they went back to the White House in November, another 8 hours there. And I would guess that a lot of this stuff is related to that. A January 6th meeting and an attorney conference. Okay, who are these people? Who are these? Are they having meetings with Liz Cheney? Probably. So interview with DC and the White House, another one. More collusion with Joe Biden. Okay, so Joe Biden has his hands and his disgusting fingers in everything. All of these are being orchestrated by them. So it is on display. Even Nathan Wade is billing for it. Talking with the White House. What for? What for? This is a local prosecution. You investigated everything on your own, didn't you? So why are you meeting with the White House counsel? Interview with DC and the White House. Very curious events there. And so it's as corrupt as it ever could possibly be. This is Mike Roman, the person who is the defendant who filed this motion. And so I want to leave you with this on this segment. Mike Roman posted this on X, and I'm going to repost this, so you can grab it on mine if you're following me. Says, Ashley Merchant, my attorney in Georgia, filed a motion to dismiss the indictment and a motion to disqualify. And it was a good one. Now, please continue to help me fight. And this is from Give, Send, Go. And I do believe that it is official just because it's now up to $47,000. And the funds of this campaign, they appear to be going to Harmeet Dillon and the Dillon Law Group. And so we are, hey, my goodness, look at this. Scott Knighton, man, thank you for going over there and making a dono. And thanks for letting them know where you came from. Says, great job. Love your filing. Mr. Robert and the Watching the Watchers fam did an awesome job going over your filings in Georgia. It's unbelievable how good a job you did in catching the catchers. Now, I am poor man, so I only have $25 to give to you. But if there's anything I can do, reach out to me, Scott Knighton, saying Trump did nothing wrong. And so, amazing, Scott. Thanks for supporting them, right? Thanks for going over there and supporting their work, because Dillon Law Group's doing some good stuff. And apparently she's working with Ashley. And yesterday, Ashley also submitted some filings. So some good stuff over there. And of course, we're going to be continuing to follow this case. This is blowing the lid off the whole Fani RICO case that's out there. And so we'll be here continuing to cover this, my friends. Thank you for supporting Mike Roman. Thanks for giving some love over to lawyer Ashley Merchant, who are doing great work. This is not an easy motion to file. I'll just say that. Okay, the DA is a very powerful position. The county attorney is a very powerful position, and they got control over a lot of cops and law enforcement and all sorts of stuff. So this is a difficult motion to file. She, might be facing personal consequences as a result of that in this location based on, the extent of Fani's power. And so she's going to need our support. We're going to be here giving it to him. And Mike Roman and lawyer Ashley Merchant are going to carry on exposing the corruption in Big Fani's courtroom. And so we're going to be here continuing to cover this, my friends. Thank you for joining us as we do. We'll look forward to seeing you back here on the next one. And don't forget to check out our website, robertgovea.com, where you can go over, you can check out, sign up for our daily newsletter. This is what the website looks like. We also have our daily show reports. When you click this reports button, you can see everything that we talk about gets summarized and assembled right here. So you're always up to date. And when you sign up for the newsletter, by clicking this button right here, you're going to get all those stories summarized and sent directly to your inbox. And it's a great way to share the show with your friends and family, forward those on so that they know what is happening now that Big Fani got Willis'd by her own Wade. Whew, it's going to be juicy. We'll be here continuing to cover, my friends. Thank you for subscribing. See you back here on the next one. All right, my friends. Now, we're not done with this January 6th stuff yet. We got to talk about Ray Epps and Cassidy Hutchinson, a.k.a. Clavicle Girl. And so let's just jump right to it. Cassidy Hutchinson, also known as Clavicle Girl, the one who swore in front of the January 6th committee, I'm telling the truth, and then proceeded to give us a bunch of garbage, apparently had a bunch of errors in her testimony to the January 6th committee. We're going to go through it. 15 pages, of filings that took place over 4 depositions, corrections for multiple dates. We're going to read through some of, you can call them lies, you can call them mistakes, you can call them bad memory, you can call them idiocy, or you can call it a cover-up by the January 6th committee that never shared with us the truth about this person's recollection, or let's say her bias. But before we go into any of that, another insane thing that happened today, more double standards. Ray Epps gets a 12-month probation sentence. Incredible, right? Now, we knew that this was not a legitimate prosecution from the beginning. In fact, he showed up on the most wanted list of the FBI as one of the most violent offenders. And when he was apparently investigated, they decided that this didn't even warrant major felony charges. And they gave him a pre-indictment plea deal that was to a misdemeanor, which he took. So he never was raided by the FBI or anything. And then today, Lo and behold, you see what happens. Sentencing got transferred into telephonic. Whoop, just flipped it over. Ray Epps called in, and the judge sentenced him to no jail. The judge's name is Boasberg, James Boasberg, held sentencing, said that Epps consented to Zoom, and he was sentenced to 12 months probation. Isn't that nice? Government recommended 6 months jail. He got 0. So he was sentenced to 12 months, special assessment, restitution totaling $500, notified about his rights to appeal, remains on personal recognizance, and he's gone. Gone with the wind. 6 months jail recommendation by the government, forgotten. 0 jail, pre-indictment, no FBI raid, nothing. And just as a reminder, this was a person who was a former Oath Keeper, who was there on January 6th, the night before, telling people to go into the Capitol, who was there at the first breach with Ryan Samsel, who was there shoving the signpost into cops violently, showed up on the FBI's most wanted list as a violent offender, made multiple incursions in multiple locations, admitted to his son that he orchestrated the whole thing, told him that, I orchestrated it. I think he went into the building because he said that in his deposition with the J6 committee, which was not recorded apparently, so we can't hear what actually transpired there. But that's my opinion, is that he actually did go in, and the questions were problematic that were being asked of them, so they didn't actually dive in. Somebody should have said, okay, you said you went in. Where was in? Like in the Capitol, in that room, in that home. Where was that? They just jumped right over it. Kinzinger moved on. So you don't really know. Now, this is a travesty of justice, obviously. We have many other J6ers who are going to prison for years and decades who did conduct a lot less serious than this. And so obviously, I think you can come to your own conclusions that this is outside of the norm. If everybody got this deal, if all the J6ers got probation, 12 months probation, okay, I would not be actually that upset about it. I said, okay, fine. That's fine. It was a riot. It was a protest. That's appropriate for that. But it's not what they're doing. They just gave it to Ray Epps, who is that entire list of everything. Now he's going to sue Fox News, probably get $1 million from that, or millions of dollars from that. So feels very fake, feels very rigged, feels like there are massive double standards, but it shouldn't surprise you because that's what this whole thing is about. Now, let me share with you as well the lies that came out from Cassidy Hutchinson's testimony. She stood there, swore in, and was paraded around by Liz Cheney and everybody as the perfect witness to detail and articulate what actually went down on January 6th. Unfortunately, a lot of it wasn't true. So this is the errata sheet. It is a notice of errors from Cassidy Hutchinson. And where did this come from? Well, Just the News reported on this, saying 3 months after she testified to the committees, Democrat star witnesses Cassidy Hutchinson submitted significant changes to statements and information that she had given during transcribed interviews. The 15-page long errata sheet, which we're going to read, uncovered recently by Representative Barry Loudermilk, includes significant changes to Hutchinson's accounts of key events that took place on January 6. The errata sheet contains Hutchinson's signature. Now let's take a look. Are these corrections or are these entirely new statements? Were these lies that she just fixed? You be the judge. But here is the errata sheet. It says attorney work product, highly confidential. After reading the interview transcript, now some of these are actual error corrections, right? Cassidy's there. They're asking her a bunch of questions. You have an awesome court reporter who's just there listening. We love our court reporters. And they're just typing away. Sometimes they make mistake. Sometimes she says a word, they think it was, something else, and they just type that down, so you make a correction. All normal. But here they say use additional paper if needed. And they say, okay, fine. Yeah, this is the attorneys who are filing this, by the way, on behalf of Cassidy Hutchinson. You can see she signed it digitally right there. Cassidy J. Hutchinson, September 12th, 2022. So they tell us she sat down for 4 interviews, Cassidy Hutchinson, multiple times in 2022. And here are just the small corrections, little corrections that she needs to clear up for us. Question to Miss Hutchinson. Miss Hutchinson, what'd you do after you left the White House? During the interview, Cassidy said, well, I was with the former president in his post-presidential operation. I primarily stayed up in D.C., but I traveled down to Florida a couple of times. Right? I was with the former president. Sounds like she was kind of like right there alongside him, right? Here's the correction. Miss Hutchinson went to Florida one time in 2021 after she left the White House, but it was a personal vacation and was not related to work. Oops. So it sounds like, Cassidy, you think like you're partners and pals with Trump, but you're a liar. Question 2. She said, and potentially having media circuits encourage people to go to the Capitol. Circuits. So I don't know if this is a transcription error, like the transcript person, the transcriber, the court reporter heard circuits, or if Cassidy said circuits, but the actual word is surrogates. Okay, so that's not a big deal. Okay, circuits, surrogates, whatever. Here's another one. Miss Hutchinson was asked, what was there discussion about it needing to happen before the joint session started at 1 p.m. on the 6th? Were there discussions about it needing to happen? Hutchinson says, no, not to my recollection right now. No, I don't recall that. No discussions. Well, they correct this. There were discussions actually about the timing of the rally. Those discussions included the sentiment that the rally should take place in the morning so that the protesters could move to the Capitol as Congress convened. Okay, so she doesn't remember it, which means she missed something pretty big. Here's another one. Ms. Hutchinson, do you know whether there was a delay or an idea of preventing the joint session from going forward on J6? Did that topic come up with Giuliani and Mr. Meadows? She says, not that I was present for. The correction says, actually, it was a topic of conversation, and maybe she was there. Don't know. Liz Fortney, name is wrong. Liz Horning. Horning is the correct name. Hutchinson was asked, was Meadows in the meeting, Cassidy? In reference to an 11 a.m. meeting on January 6th. Was Mark Meadows in the meeting, Cassidy? I'm not sure. I was not in the West Wing at that time. Turns out Mark Meadows was in the meeting at the Oval Office on January 6th, so she didn't know that one. Ms. Hutchinson was also asked, did you ever learn from speaking with Mr. Meadows or anybody else in the White House that the Trump had placed a call to Pence the morning of J6? Hutchinson said, yes, I was aware. Meadows had spoken about it, nothing specific, just that he was going to call, that he was trying to get a hold of the vice president. Now, they correct this. Miss Hutchinson learned that Trump called Pence the morning of January 6th, and she learned that Trump was irate on that call. Clarifications there. Same response in that one. Here, how about this one? Ms. Hutchinson was also asked, do you remember any of the specific items that any of the people mentioned to you, and specifically dangerous items, not the flags or the poster boards? She said, I don't recall the word dangerous being thrown around in association with the item specifically. But I remember generally that there were individuals who had, American flags that were too large, which in my opinion is irrelevant, but it's not a dangerous item. She also said she heard about bear spray and pocket knives. Now here, so they correct her record, okay? So they actually fix this for her. No, I didn't hear about any dangerous weapons. This is actually a truthful statement that they modify. American flags, those aren't a crime. Bear spray and pocket knives. They say, no, Cassidy. Sorry, let me correct you. You heard there were knives, there were guns, there were pistols, there were rifles, there was bear spray, there was body armor, there were spears, and there were flagpoles. Just to correct the record. So she's like, no, there were no weapons. They're like, yeah, there were. You heard all about them. And they make their record known. Got it. Hutchinson, what about firearms? Do you remember any reports of firearms coming in? She says, no, not that I can recall specifically that morning. I don't remember any firearms at the rally site. They say, oh, yes, you do recall. She says, I don't recall, nothing I can recall. They say, yes, you do. Miss Hutchinson recalls there were reports of firearms at the rally. Wow, interesting. I don't recall anything becomes she definitely recalls. So maybe Cassidy's not lying. The people who are fixing this are lying on her behalf. Here's another one. Mr. George asked Cassidy, did you tell Mr. Meadows that there were reports of bear spray, pocket knives, and other things people were finding at the rally? I remember talking to Mark about this and having conversations, but I don't recall if I specifically listed those items. Okay, but do you remember specifically telling Meadows that there had been bear spray or knives confiscated amongst rally attendees? Like they're trying to make her have this answer. Hutchinson says, I don't recall specifically what I had said to him. I know that I had told him that there were a number of people who weren't permitted entry because they had items that Secret Service deemed as dangerous or non-permissible. I don't recall whether or not I listed off specific items that had been relayed to me. It's very possible I did. I don't recall. They say Miss Meadows relayed that there was bear spray and knives. Miss Hutchinson, what was Mr. Meadows' reaction about the dangerous items that the Secret Service mentioned? Hutchinson says, I don't recall specifically. I don't know. Now she remembers. They correct the record. Mr. Meadows was unimpressed. He was not concerned that there were dangerous items. He was not concerned. Okay, she didn't say that. They did. Miss Hutchinson was asked several times, did anyone tell Mr. Trump that there were weapons there? Hutchinson was asked, so are you aware of whether or not the president was ever told that there were people outside with pocket knives or bear spray? Again, pocket knives for your insurrection, to steal the whole country. That they wouldn't make it through the magnetometers? Hutchinson says, she says, I did not know whether anyone told Trump that there were weapons in the crowd. They didn't even give us her quote. They just said she responded saying, I didn't know. But they changed that into Miss Hutchinson was aware that Trump was told there were weapons in the rally. A total correction. Hutchinson was asked, can you tell us what you remember about Trump saying about his movement to the Capitol? She says, Trump wanted to make sure that we had exhausted all of our resources and our communications with Secret Service and other individuals that were present to ensure that we truly did not have the assets to transport him to the Capitol. Actually, we might be able to logistically make it happen. So she explains it and they correct it. Nope. It says President Trump would not accept that he was not able to go to the Capitol. Trump continued to say that he was going to the Capitol, even though she gives us a more correct answer. So like they want to delete this, okay, from the transcripts. Hutchinson was also asked, so in other words, the president wanted you to make sure that this is an absolute no, right? Like he cannot go to the Capitol. Like you can't do this, Mr. President, before he was willing to accept that he wasn't going to the Capitol. Is that fair? Yeah, before he was willing, yeah, that's a fair assessment. So Trump said, I'm absolutely going unless I can't. Same response. Same response, which is Trump would not accept that he would not go to the Capitol. That is not what she said. Trump would not accept that he wanted to go to the Capitol. She said, literally, that Trump accepted it once they said it was not possible. Like, that is a different statement. They are liars. Miss Hutchinson was asked, did you ever find out what happened with the conversation in the Beast between the president and Mr. Engel? Look at this one. Hutchinson said, well, yeah, Trump talked to Mr. Engel. Conversation was just that Mr. Engel had relayed the message to him and Mr. Ornato, discussed previously knowing that there was no developments that would have changed the guidance, that we didn't have the assets, and we just reconveyed that to Trump. Now here, they correct this. President Trump, they say, rode from the rally to the White House. Hutchinson was told by Deputy Chief of Staff, Tony Ornato, that Trump got into the SUV. This is the clavicle part. Trump got into the SUV with Mr. Engel and that the driver, that President Trump insisted the car go to the Capitol. Mr. Engel told the president, no, it's not safe to take you. And then, apparently Cassidy never said this, and then Trump lunged forward at the steering wheel, and Mr. Engel reached for Trump's hand, and that Trump lunged towards Mr. Engel. This is the clavicle. Okay, Cassidy said that Trump was like, you're taking me to the clavicle. You're taking me to the Capitol, I mean. And grabbed him by the clavicle. But they didn't include, she said clavicle officially on the January 6th committee tapes. We've gone to the tapes on that. But where's the clavicle portion here? It's not in there. Now, what's curious about this, as we'll see, Ms. Hutchinson says, so who relayed to you what happened in the beast, the clavicle? Well, I just know that Mr. Engel had said that we'll talk about this on the car ride back. It's something of an iteration. It's not verbatim. And once the motorcade had arrived back to the West Executive and we had all made the movement back to the West Wing, I had resettled in my desk at my main desk in the main chief staff area. In a couple minutes, I waited to see Ornato. And I just had a brief conversation with him. Do you know if this issue was resolved and it's closed, so I don't have to follow up with Meadows anymore? And he said, yeah, all good. He said him and Mogul talked about it, or sorry, him and POTUS talked about it. They correct that. It says deputy staff told Hutchinson what happened on the drive. Miss Hutchinson, do you know what Mr. Meadows or what Trump was doing in the dining room during these periods on January 6th afternoon? She said, I'm trying to be specific and draw the line between, obviously that's been reported after the fact. She says that day, I knew that there were people in and out of the Oval Office with him that afternoon. The TV was on. I knew he was watching the news, which wasn't anything out of the ordinary at all. But substantively, I'm not sure that I could speak to his specific activities or conversations other than that what was reported after the fact. Okay, no idea what's going on. They changed that whole paragraph. Okay, that's the old correction. Look at this correction. Ms. Hutchinson was aware that hang Mike Pence chants occurred in the dining room. Did you hear any of that in anything she said right there? What is that correction? They're just making crap up? She didn't even say that. Hang Mike Pence at all? It's not even in the question or in her response at all. They just made it up. That's the January 6th committee that we're dealing with. They just make it up. Not even in the question or the response at all. Here, Miss Hutchinson was asked, you mentioned earlier that there was one point when you went into the dining room with a message from Mr. Meadows, from a member. Could you tell us what that memo was from the member? She says, well, just to clarify, I didn't physically go into the Oval Office dining room. And this is just logistically, I want to make sure I was clear in my response. You walk down the hallway, but there's like a butler's pantry, and that's where the president's military valet would be, and then the Oval Office dining room. And so I asked the valet to get the chief of staff for me. And so the valet opened the door. Chief of staff stepped out, and I had relayed the message from Jim Jordan. He had called my work phone, and we had a brief conversation. He said, hey, where's Mark? I told him he's down with the president. He said, can you have him call me? And I went in and asked Mr. Meadows to call Jim Jordan. And he said, all right, I'll do it. And then I went back to my desk. What did they change that into? Mr. Jordan did not call Hutchinson's work phone. Jordan called Meadows' cell phone, which Meadows gave to Hutchinson. So Hutchinson then received a phone call from Mr. Jordan. She walked to the president's dining room. When she told Mr. Meadows that Mr. Jordan was on the phone, Mr. Meadows stepped out of the president's dining room to take the phone call. Right? And so this really tightens it up. So this makes it sound like she can't see into the room, right? So she doesn't know if hang Mike Pence is going on, which is they're trying to fabricate right here in the dining room. Okay, so she can't see into the Oval dining room. She admits that, and they modify this to say, yeah, she walked in, knocked on the door, and just looked at the whole thing, watched the whole thing happen. So they just changed the story. Here's another question. about a text message on a palm card. It says, anyone who entered the Capitol, Hutchinson, without proper authority should leave immediately. Do you recognize this card, Miss Hutchinson? She says, yes, I do. That's my handwriting on that day. Now, I don't remember who relayed this message to me. I was writing very quickly. There was somebody who had called me on my work phone, and this was a draft tweet that this person felt would be useful if it went out from Trump's Twitter or from another media surrogate. And I remember writing this message down, giving it to Mark, and giving him the context in real time. But I don't recall who gave this message to me, though. That's her statement. They say they change all that. Mr. Meadows stood at Miss Hutchinson's desk and dictated what Miss Hutchinson wrote down. What on earth? Hutchinson literally says, I don't know who gave me this. Someone called me. I have no idea where it came from. I was writing this down, and then I gave it to Mark. I gave it to Mark. They say no. Hutchinson was seated at the desk, and Mark told her to write it down. It is not the same. Like, it is not the same at all. They just changed it because this is not what they wanted. They wanted Mark Meadows orchestrating this whole thing. Miss Hutchinson was also asked, did you learn that the president was reluctant to send out a message? She said, well, the information that was made available to me wasn't necessarily that the president was expressing reluctance. It's that the president was being strategic and selective with how he was going to relay this message. Here's the correction for the record. Miss Hutchinson knew that Trump did not want to make a message to address the situation. Again, that is not what she said. These people are just recreating history out of thin air. This is the correct answer. Actually, Hutchinson is right? Trump, it's not like I'm going to let them torch the Capitol. He's responding. Okay, he's the president. He's got discretion on how to handle this thing. So here it continues. Miss Hutchinson was asked about John Eastman and the Eastman theory. Based on your interactions with Meadows, did he agree with Eastman and his theories about Mike Pence? She said, well, Mr. Meadows was open to hearing theories from individuals that had knowledge and was conducting research. I didn't ask his personal opinions on this, and he, to my recollection, didn't share anything with me that hasn't already been elaborated on. Correction. Mr. Meadows stated that he would do what he could to push the theory forward. Cassidy Hutchinson, as a witness who is providing evidence, says something, they just change it. Mr. Meadows knew that the Eastman theory had not been tested before, but because Meadows wanted to be the one to keep Trump in power, Mr. Meadows was willing to push that theory. Not what she said at all. Mr. Meadows knew that voter fraud theories would probably not be successful, and he wanted to find a different way to keep Trump in power. Did she say anything even closely related to that? I have no idea what happened, no knowledge of anything. Meadows, from her, like they're saying this came from her. This is not like a correcting, like, well, she was a little bit wrong on this. Here's more details. They're saying this is her testimony, which it is not. Hutchinson was also asked, now she signed this, by the way, so she's just as much as fault. Do you know whether the president wanted to do a video on the 7th? On the 7th, is that right? Miss Hutchinson said, I do not. But then they changed that. I do not know whether Trump wanted to do the video. They changed that. President Trump did not want to make the video, which is not at all what she said. Now, Hutchinson was also asked, were you aware of any discussions about the need to include references to Antifa when discussing the events? Antifa. She said, well, I was not privy to the conversations to include a word or acronym Antifa in any of the correspondence and after the events on J6. They say there was an emphasis on blaming Antifa. Okay. So here's another part of the transcript. Another meeting. Apparently we got a full name wrong. So they ask a question, just so to the best of your memory, was there anyone else in the room at the time? She says, yeah, there was a bunch of people in the room on January 4th at a conference room. Who was there? Marjorie Taylor Greene was there, Lindsey Graham, Senator Graham, Meadows, myself, Mr. Trump, Johnny McKenty. There were other individuals, and I was in and out of the room. I wasn't in there during the entire flight, though. And they replaced Johnny McKenty with Nick Luna. So got a whole name wrong on there. Johnny McKenty versus Nick Luna. But you could say, okay, that's why you do these. You just make a correction. Okay, got the name wrong. Now, here, she says, I did have a conversation. They corrected this. I did not have a conversation. Maybe that's true. Maybe she just jumped over a word in the transcript, like you don't know. Here's another one. Hutchinson was asked, and so where were you when you heard this in reference to chants about Mike Pence? So this is right when I stepped in to give Meadows the phone. Now they say rather than step into the room, Hutchinson held her foot in the door. Hutchinson said O'Brien, wrong name, Keith Kellogg. Another O'Brien, wrong name, Keith Kellogg. PBD corrected to PPD. She says, so I put him through. They changed that. So she put him through. It's kind of a big one. The subject. Hutchinson refers to one of the names of the valets. Okay. They call him Mike. She says, yeah, Mike. But there's a slight possibility that the valet was Walt Nada. And that's not spelt correctly either. Nuda? No, it's Nada. Nauta. Rather than Mike. So you need a notice of errata on your notice of errata. Hutchinson said red manila envelope, red manila folder. Okay, no problem. Eliza, no problem. Hutchinson was asked, says, and Mr. Perry, meaning Scott Perry, wasn't he at the meeting with Waldron, McGuire, and Higgins? And she says, that is correct. He was there. Scott Perry was at the meeting on December 29th, whatever that update is. Tallying satellite is Italian satellite. Okay, so that's like a transcript error. Reacted with her, was raised with her. Tenure equals knowledge. Just an incorrect pickup of a word. Lazy was laissez-faire. Vert was very. Now here's a question. Ms. Hutchinson was asked, what about the pardoning the president himself? Did he ever talk about that? She says, I heard Mr. Meadows mention that about pardoning himself, but in a passerby conversation with me. If we're all going to do these pardons, the president wants a pardon. I want a pardon, just like in the same breath of the conversation, we're all getting pardons. And I believe I sat down with him about pardons, but I was getting inundated from member requests, not necessarily asking for personal pardons, but with their constituents. They wanted to pardon whoever it might have been. We had hundreds of pardons of requests, if not thousands. And that's when Mr. Meadows had mentioned some staffers are asking for a preemptive pardon. Some campaign people are asking for a preemptive pardon. Heck, if all these people are asking for a pardon, I might want a pardon. Even the president might get a pardon. They should have all gotten them. They should have pardoned all of themselves because now they're being prosecuted by their political opponents. And saying that bolded section should be read in Mr. Meadows' voice. Now, what's curious about this, let's go back to the clavicle attack. When recounting Trump's trip from the ellipse to the White House, Hutchinson said that Trump attacked the clavicle of the driver. Now, Hutchinson stated that Trump rode in a presidential limo, right? Hutchinson stated, when the car started moving, I'm under the impression from the story that Tony told me, it just made Trump irate. And he lunged forward into what I believe would be called the cab of the presidential limo. And he went to grab the steering wheel in the presidential limo. Remember that? We heard the story, the clavicle attack. Problem. Trump didn't ride in the limo. Trump rode in an SUV. Derp. They asked her, did they explain, Cassidy, like given how the layout of the beast, which is the limo, did they explain like the distance, that it would take for the president to have to lunge to get at the steering wheel, right? Like you got to go all the way down the limo. Trump's kind of a big dude. Then they're going to lower the thing and he's going to reach across the clavicle. On the trip, Trump didn't ride in the beast, Cassidy. He rode in the SUV. And also, this is all hearsay anyways. Okay, so like Hutchinson was hearing this from another person who saw it. So they could have brought him in to testify, but they didn't. They love this story. So she is dead wrong on the clavicle story in the first place. It's not even the right vehicle. And she heard it from another party and has got the details wrong. She said, I know that Trump, like this is her. I know that Trump would typically sit towards the front of the limo because he would have conversations with the agent in charge. He would do that with Tony when Tony was in the same position Bobby was in. So I've never been in the Beast, but from what I understand, it's a relatively short distance to have that conversation. Now, I don't know if he would have been able to grab the steering wheel or if he was just trying to lunge at it. Wasn't even in the limo. Cassidy, thanks for the story. But she also said late in the evening on January 19th, around 10:30, that Pat Philbin came down to the office and asked me for the binders, referring to the 2 binders that were given to Leader McCarthy and to McConnell. I then gave them to him. And that's not true. She actually gave one of the 2 binders to Pat Philbin, not both of them. So all of this confirmed by Cassidy Hutchinson, by her lawyers. And you can see some of these are just absolutely benign. Like, it's not even a big deal. You just say, okay, yeah, lazy is laissez-faire, right? Her laissez-faire or something. Said it sounded like lazy. Or maybe Cassidy said lazy, but she meant laissez-faire because it's a hard word. So some of it is pretty benign, pretty insignificant. But others, like missing key facts about the Beast and the limo, makes her entire Clavicle story, which was like the highlight of the J6 committee, all less credible, entirely lacking in credibility. And then they just change everything, saying that to her recollection, don't know anything about it. And they just change the story. Mr. Meadows stated that he would do everything he could to push the theory forward. No, she didn't say that. Like, literally didn't say that. So they just went back. They changed everything. They said, we're going to get you a book deal. We're going to get you on MSNBC. You're going to be joining the Spice Girl anti-Trumper team. And you're going to go out there and go after Trump. And of course, that's what she's done. That's what she's doing. So Cassidy Hutchinson signed off on this document, which in my opinion reads like a bunch of lies. Like, they just took what they didn't like, they rewrote it, and they sent that back to the committee. And then Liz Cheney brought her out and shoved her down our throats. And you can see it's part of the actual big lie. They're covering up for Ray Epps. They're covering up for Cassidy Hutchinson. They have to fabricate this insurrection because it didn't happen. And so we're going to be here continuing to cover this, my friends. And I thank you for joining us as we do. We're going to see if any of this comes into play in any of the Trump trials. I mean, I think that it might, because she might be a key witness in this whole thing. And it turns out her testimony is not accurate and borderline illegal. You know, it's new testimony. It's like lying. So we'll talk about this as we carry on, my friends. Thank you for subscribing and sharing this with another friend or family member so they can come over here and see the truth about what's happening. And we'll look forward to seeing you on the next one. All right, my friends, we're not done yet. We got one final segment on the day. And for this one, we're going back to D.C. Court of Appeals. And here it goes. Donald Trump celebrates oral arguments that took place in Washington, D.C., the Court of Appeals. The issues there, presidential immunity and double jeopardy. And the judges who are hearing these oral arguments are part of a panel, 3 judges only. And here is what they look like. You can see 3 judges here, Judge Michelle Childs, Judge Florence E. Pan, and Judge Karen Henderson are all the judges. And we've been thinking of them as sort of like tier 2 Fani Willis's, Jenna Griswold, and Shenna Bellows, you know, kind of the same look and vibe to them. And so we've been dealing with a bunch of state court people. Now we're at the Court of Appeals, and these are the judges who are going to be hearing the case. And so you can kind of figure out where this is going to go since they shop at the same stores and go to the same hairstylists. But this is from Julie Kelly, who did a deep dive on Judge Florence Pan, this judge, and we know a little bit more about her thanks to this research. And here is what Julie Kelly tells us. They say, here's some info, and you can follow her at Julie_Kelly2 on X. She's also got a great Substack. Says here, one of the judges on the 3-panel hearing, Pan, was appointed by Joe Biden, no surprise there, and is married to this guy called Max Stier, a Democratic Party activist and one of Brett Kavanaugh's chief antagonists. Stier, the husband, claimed that he observed Kavanaugh engage in lewd behavior at Yale. Remember that whole saga with Blasey Ford? He reported it to the FBI and to the Senate during the Kavanaugh debacle. He was recently featured in a film about Kavanaugh that also criticized the FBI investigation into the Kavanaugh claims. Been around for a long time. They say that Pan has friends in high places. In one of her first hearings on Wednesday, from a Washington Post article, Pan took over the politically sensitive lawsuit brought by the Trump campaign advisor Carter Page against the FBI. Remember that? Saying that he was unlawfully surveilled by the FBI. Pan offered to recuse herself, saying she was friends with lawyer for the FBI, Lisa Page, former FBI lover. Pan said she's known Page's attorney, Amy Jeffries, former DOJ lawyer, for 27 years and went to her wedding. Now, Amy Jeffries is also married to another DC judge called Chris Cooper. And Merrick Garland officiated their wedding. Oh my gosh, it's like one big incestuous, disgusting gutter. Now, the three judges are supposed to be randomly selected. We'll see. Pan was decisive in both decisions upholding post-Enron statutes, and her opinion is currently on review as well. Pan and Childs, they upheld Judge Beryl Howell's non-disclosure order, preventing Twitter from notifying Trump about any of this stuff. And they also ruled to pierce attorney-client privilege between Evan Corcoran and Trump. So these judges, we know exactly what's going to be happening here. If you want to read the rest of this, go follow Julie Kelly. So you can expect what's going to happen here. I think that these judges, before we even listen to it, are obviously going to uphold Chutkan's order and send this case back down. And then Trump will appeal to the full panel. They'll probably reject that. And then Trump will take it up to the Court of Appeals. But while this was happening today, there was a very interesting thing happening. A bunch of DC journos, evidently. This is from Unlimited L, saying journalists were caught on a hot mic joking about Trump's elimination. Saying, you know what the worst part is? Even if he has his window open and he's hanging out on it, he will be on the other side of the street, which is just a disgusting statement. So maybe they said, yeah. So anyways, I'm not going to play this actually, but there are journalists out there who are joking about eliminating Donald Trump. And if you want to listen to the audio, you can go check this out. Unlimited_Ls to hear them joke about it. So it's just disgusting, right? They're all, I guess, thinking it's just a big giant joke, what's happening out in DC. But we're going to fast forward through that. And judges, they're asking questions during oral arguments. Here is the question. What if Donald Trump executed his political enemies? Okay, so while the journalists are joking about him being taken out on the streets of DC, the big question of the day came from Judge Pan to defense attorney John Sauer. And the question is, could Donald Trump assassinate his political opponents? Could he use SEAL Team 6 to just take him out? And this is a wild question. Here's what John Sauer says in response.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, that was, as long as it's an official act. I mean, certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that as long as he's not in office. But as long as it's official act.
Could a president order SEAL Team 6 to assassinate a political rival?
Great question, Judge.
That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
No.
If he were impeached and convicted first. And
so your answer is
no. My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders are much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
Right.
I've asked you.
Yeah. So this is actually a pretty simple, cut and dry situation. We are a lot less worried about the president using SEAL Team 6, I don't know why she picked them, to go eliminate their political opponents. That's a lot less likely than partisan prosecutorial hacks trying to prosecute and remove their political enemies. They're not the same thing. Now, his answer is good, right? Yes, but qualified. You could prosecute someone like that, but you have to go through a preliminary step. This is not different from criminal law in general. In criminal law, you don't just get to convict someone, even with a felony. You have to have a preliminary hearing or an indictment by a grand jury. There are steps where you have to determine that there is probable cause to move to the next level. It's not even complicated here. When it's a political prosecution, or we're worried about that, you have to have a preliminary hearing to go through the House and the Senate to make sure it is not political. And how do we know that? Because there's overwhelming consensus from all parties that this is criminal. And so that would happen very quickly. And if they didn't, right, if they decided we're not going to impeach and then convict this person, then that has not been met. Same thing in criminal law. If they try to indict you, but there's no probable cause, there's no charge. So that means that they don't think there's enough evidence there. That's due process, and they hate it.
You a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted?
Requirement.
And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first. We may be saying the same
question
thing.
was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Okay, so
sale of military secrets.
Yeah, so she just changed. So these judges, they're not even that good either. She just changed her question and then added in two other variables.
Strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
But your brief says that communicating with an executive branch agency is an official act, and communicating with a foreign government is an official act. That's what presidents do.
Those are very strong situations. Those are very strong examples of potential official acts. If you look at what Chief Justice Mitchell said against Madison, he said, rising directly under Article 2, Section 1, that...
All right, so the audio gets a little bit wonky and a little bit bad here, but let me see if I can fast forward a little bit. Okay, I've got some other clips here, but the answer, the process is, yes, you have to impeach them, then convict them, and if it's actually criminal, both parties will do that, and it will happen rapidly. But if it's not, if it's a political attack brought by, let's say, Nancy Pelosi, who wants to fake, an insurrection claim, then it's not going to meet that threshold and you're not going to be able to be prosecuted. So here's another one from Judge Pan and from Judge Childs. And this one also came from John Sauer. They're asking about more immunity conduct and what happens under different scenarios.
If you have the impeachment judgment clause, as you indicate impeachment, then conviction, but then the president either resigns, is removed, and then later on is prosecuted for a different crime. Can that happen, or is there immunity there?
I'm not sure I understand the hypothetical. Could you say it again? I apologize.
Just indicating that if you're resting on that there must be impeachment and conviction, and it's for one set of crimes, but then later on the president either is removed from office or resigns, and later on, there's a prosecution for something different. Is there immunity for that later crime?
Yes, I think that's the better reason. Obviously, it's not presented in this case because we have a close match between the conduct, the underlying conduct or transaction occurrence that's alleged in the articles of impeachment, of which there was an acquittal.
Okay.
An acquittal, right? Which is the strongest case for double jeopardy and between the facts alleged in the indictment. But if there were like an unrelated prosecution,
you just made a statement about he's only being prosecuted for crimes while in office. And so that's why I'm asking about leaving office and then thereafter being prosecuted for something different.
In fact, to be under the plain text of the Constitution, the best reading would be he has to be impeached and convicted for the thing that he subsequently prosecuted. So if he were impeached, convicted, and removed from office, and they charge him with another official act that was unrelated to the impeachment, I think that what Chief Justice Marshall says in Marbury would still govern. I think that's obviously it's not presented in this case. The court doesn't have to decide it, but that'd be my answer.
So I just want to confirm.
Okay, so we're asked, the questions are not that great from these judges. We have them asking about general immunity. And so he's just, general immunity all over the place. What I thought that judge was asking is what happens if Trump is no longer in office and then commits a crime, like does something otherwise criminal. And he didn't take that question that way, right? He's basically saying, well, if you remove Trump, the idea would be if you remove Trump or he's no longer in office and then you want to hit him again for another official activity. That's how he answered that question.
Your position is if President Trump had been convicted after his impeachment trial on incitement of insurrection, if he'd been convicted, then this prosecution would be entirely proper.
Which I would say that if you were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. So we have many other issues with this prosecution.
Is that a yes?
So I do.
Because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related conduct as that which is in the indictment.
Yes.
Yes. Yeah, I agree with that.
So
her question's very overbroad. Okay, so she's trying to zoom in on this. The point is, Trump was impeached for the January 6th conduct. He has not been charged with insurrection on the January 6th case brought by Jack Smith, on which we're arguing now, claiming immunity. But he is being charged for the same conduct, right? It's January 6th conduct. So he's saying that the impeachment essentially immunizes him against this. If he would have already been convicted, then they could have brought those charges up against him. But her question was very overbroad, you heard her say. So if that would have happened, then this entire prosecution would have been perfect, right? No, we also have a bunch of other problems in this case that would also disqualify this. And so I'm not going to give you that, Judge.
If he had been convicted by the Senate, then this prosecution would be entirely proper, correct?
Well, I would not phrase it that way because there's lots of other problems with this prosecution that we've raised in extensive pleadings to the district court. He could be prosecuted.
Under the impeachment judgment clause, if he had been convicted by the Senate when he was impeached for incitement of insurrection on same or related conduct as what's in the indictment, then this prosecution would be properly brought.
There's a prosecution could be properly brought. This prosecution, which has tons of other problems with it. I just want to be very clear about that. I'm making any concession that this prosecution is.
All right, let me try one more time. Under your
Ask a better question, Judge. He's not going to say this is the only, this immunity issue is not the only thing that they're hanging this case on. She's trying to make it that way and he's not buying it.
The impeachment judgment clause. If President Trump had been convicted when he was previously impeached on same or related conduct as that which is in this indictment, the government could properly prosecute him for that same or related conduct. Yes or no?
Potentially, provided they qualified with all kinds of other legal doctrines that are violated in this case.
Yes.
So I admit that a prosecution.
I'm only asking you under your interpretation of the impeachment judgment clause, is that proper? Is that allowed?
I stand on my prior answer. I think we're agreeing.
I understand there might be other reasons why you would challenge this prosecution. I'm saying based on your interpretation of the clause, this prosecution would be properly brought.
I would not say this prosecution.
This prosecution. Judge needs to say a prosecution. A prosecution against a president could be brought if a president is impeached and convicted. You can then bring a prosecution on a similar charge. She keeps trying to bring it to this case. I'm not going to say that, Judge, because there's other problems in this case that we're going to, be here next on.
Clear about that.
But it's a prosecution based on same or related conduct.
This prosecution, which has many other issues related to it, what I would say is that the impeachment judgment clause authorizes the prosecution of a president who's been impeached and convicted by the Senate, which President Trump.
All right, we'll make it a hypothetical.
Thank
Say
you.
a president was
Thank you, Judge.
impeached and convicted on a charge of incitement of insurrection that is under the same allegations as a criminal indictment. He's convicted. Then the government could bring a prosecution for the same or related conduct, correct?
Don't disagree with that.
Okay. And then
You see how bad the question is? He says, yeah, I agree with that totally. No problem.
that means that the conduct that's same or related, even if it's official, he could be prosecuted for it, correct?
You're convicted.
Correct.
Yeah.
Okay, thank you.
But my question goes to after the fact, and
They got it. It's like, wow, amazing. You guys figured it out. Congratulations. You got to be impeached. Just like before you can be charged with a crime, you have to be indicted. There's a procedural safeguard. Hello? Just like you got to have a preliminary hearing if you want one. You know, there are these procedural mechanisms in place, and man, it feels like Judge Pan just finally got it, like she got, educated.
the reason I state that, even though you're challenging that these actions are only occurring while president, the district court's decision was that there is no presidential immunity from prosecution for official acts. It doesn't put a time frame in there. And so that's why I'm going to beyond your investigation, your prosecution might not come until later, after the president has left office. So are you telling us that we are limited to a time frame in answering this question?
I think the time frame is set forth by Chief Justice Marshall against Madison when he says never examinable by the courts. So unless there is that one gatekeeping incident that has to occur, which is impeachment and conviction, the official acts, the court has no jurisdiction to review them under the separation of powers and the executive vesting clause.
But that also assumes that an impeachment proceeding occurred. If there is not one, because we discussed earlier that not all officials go through that process.
Absolutely.
That's a judgment call
Right.
as to whether that process would even be brought.
I would say we have two arguments that reinforce each other. So if there's no impeachment ever and no conviction, then the official acts are immune, period.
Yes, that's it.
Further, the impeachment judgment clause incorporates a doctrine of double-jeopardy that prohibits it, especially in the case of acquittal. So those are reinforcing doctrines that are.
It's so good. So John Sauer is absolutely right about this. And what's so fun about this is he keeps referring to Marbury versus Madison. Okay, you cannot substitute your judgment in for the president's. You can't rule and judge on official acts of the executive branch. Otherwise, that makes the courts the executive branch, right? They're the presidency. So immunity stems from that, right? You can't suddenly decide that other branches of government or other people can, go and prosecute those people. It violates separation of powers. So he's referring to Marbury versus Madison, doubling down on that doctrine because these courts, they're not going to overturn that. That's like the most important case in American history. Like, it's not going to get overturned. So you want to overturn this? Overturn Marbury versus Madison. See how the Supreme Court likes that. Now, here's a question on double jeopardy, a couple other short clips, and then we'll hear Sauer's rebuttal. This one came over from our friend Simone Ateba, reporting for Today News Africa. He clipped this for us. Here's a question about double jeopardy.
Say that if you were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. Because we have many other issues with this prosecution.
Is that a yes? Because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related.
I think we heard that one in that second CNN clip. So we're going to fast forward through that one, and then we're going to just jump right to John Sauer's rebuttal. And so here is what he said in response
3 points to the court
to a bunch of the oral arguments that took place today.
in response to the opposing counsel's argument there. One is that the opposing counsel used the phrase above the law, saying that an immunity doctrine for criminal immunity would place the president above the law. I would just direct the court's attention to what the Supreme Court said in Nixon against Fitzgerald in the context of civil immunity. They described the allegation that immunity sets the official above the law as, quote, rhetorically chilling, but wholly unjustified. The U.S. Constitution, the separation of powers, the executive vesting clause, the impeachment judgment clause, these are the foundational and fundamental law of our country, and the president's immunity is determined on that. So that is more rhetoric than reality, is what the Supreme Court said in Nixon against Fitzgerald. I'd also point out that when it comes to the question of whether or not the indictment alleges solely official acts, the indictment does not allege that President Trump did anything wrong after he left office. So it focuses solely on acts that he took while he was in office, and that's a telling indication that we're dealing with official acts here. And then finally, I would address Judge Henderson's, your question about the floodgates. And I tie that to what my opposing counsel said about a so-called frightening future. The frightening future that he alleges where presidents are very, very seldom, if ever, prosecuted because they have to be impeached and convicted first is the one we've lived under for the last 235 years.
Boom!
That's not a frightening future. That's
Boom! There's no frightening future going on here. This is how it's been forever. You guys are trying to change it.
Republic. What he is forecasting is a situation where the floodgates will be opened. We are in a situation where we have the prosecution of the chief political opponent who's winning in every poll. Presidential election upcoming next year and is being prosecuted by the administration that he's seeking to replace. That is the frightening future. That is tailor-made to launch cycles of recrimination that will shake our republic for the future.
So good. All right. So John Sauer, attorney for Trump, just hitting that one out of the park. This issue is so, it feels obvious to me that I have a hard time believing that the DC Circuit can find any other way, but I know that they will. So they're going to craft this, right? They're going to, I think, support Judge Chutkan, and they're going to find that the prosecutions can move forward relatively quickly. And then we'll see Trump appeal to the full panel, probably be denied there. Next stop is going to be the Supreme Court. And so Trump was there, and he actually responded to this, says, I've done nothing wrong. We had a good day in court. Our attorneys did great. John Sauer did an amazing job. And here is what he said at the day.
Well, I want to thank you all, and we had a very momentous day in terms of what was learned and what they've conceded. They conceded two major points that were they were right in doing it. I don't think they had much of a choice, but they're very, very big, very powerful points. And I think we're doing very well. I think it's very unfair when a political opponent, is prosecuted by the DOJ, by Biden's DOJ. So they're losing in every poll. They're losing in almost every demographic. Numbers came out today that are really very mind-boggling if you happen to be Joe Biden. And I think they feel this is the way they're going to try and win. And that's not the way it goes. That'll be bedlam in the country. It's a very bad thing. It's a very bad precedent. As we said, it's the opening of a Pandora's box, and that's a very sad thing that's happened with this whole situation. When they talk about threat to democracy, that's your real threat to democracy.
Totally.
And I feel that as a president, you have to have immunity. Very simple. And if you don't, as an example, if this case were lost on immunity, and I did nothing wrong, absolutely nothing wrong, I'm working for the country.
That's right. Trump did nothing wrong. Trump is innocent. And he was trying to make sure we have free and fair elections. And they're prosecuting him because a lot of the American people stand behind him, and they cannot let us vote for him. So they've got to indict him. They've got to remove him from the ballots. They got to imprison him or worse. And so we're going to be here continuing to cover this. Of course, I think that the court is going to issue a ruling relatively quickly because they want to support Chutkan and getting this trial back on track. But then Trump will appeal, and ultimately this puppy is going to go up to the Supreme Court. And so we're going to be here to continue to cover this. If you want to stay plugged in and get up to date on everything that we do here, head on over to robertgovea.com. We have our daily newsletter. You just go there, click this button right here, sign up for it. You'll get access to the mind map, and you'll get all of these show reports delivered to your inbox every day. So we just summarize the show, put them on, post them on the interwebs, and send them to you. That way you can forward them to your friends, to your family, so that they also can join us and know what is going on as the DNC Democrats, Biden administration, all come after Trump day after day. We're just warming up here, my friends. It's going to be a busy year. And so we'll look forward to seeing you right back here on the next one. All right, my friends. Well, we covered some good ground. Immunity arguments at the Court of Appeals in D.C. Cassidy Hutchinson's lies, her corrections, her erratas, all been adjusted, and now we know the truth about it. We also had Fani getting WILLIS'd by her own Wade, her Nathan Wade special prosecutor, getting indicted on her own account. And so now it is time to hear from you. We are going to go over to watchingthewatchers.locals.com. This is our members only community. We got the best members ever. And we do members only streams in the morning. We do Saturday shows, and it's a lot of fun. So come check us out, watchingthewatchers.locals.com. We really try to deliver for our members. because we're building the community. We also got Robert Gouveia, told you about that. Now, let's see who is in the house on this beautiful, beautiful Tuesday. We got Patrick Rocco is our newest supporter over on the YouTubes. And so if you're on YouTube, by the way, and you want to join us for our after party and you're a member on YouTube, navigate to the channel homepage, go to the community tab, scroll down, grab the Telegram link, and we'll see you there after the party, for the after party. We got Jason Finch, 1 month into the pregnancy. Congratulations, Jason. I can't wait to see the baby. We got M. Jank is in the house over on Locals. Says only Democrat presidents have immunity to use SEAL Team 6. Yeah, and it would have been interesting to say, like, yeah, you know, if if Biden executes Trump using SEAL Team 6, yes, we have to impeach him and convict him. Like, that would have been a great answer. Yeah, like, so for example, Joe Biden, like if he were to shoot and kill Donald Trump, we have to impeach him and convict him. That's true. You're right. Good hypothetical, Judge. Hey, this one from Glocky says, no matter how much you hate the fascist judiciary, especially in DC, it's nowhere near enough. Talking about Ray Epps, says Democrats said Trump told his insurrectionist followers to go to the Capitol, but also Democrats. Yes, Ray Epps told people to go into the Capitol, but so what? Stop it making this political. Leave this guy alone. Yeah, Ray Epps is under attack. It's wild. Kinzinger loves him. Cheney loves him. Everybody's like a fan of this guy, even though he admitted to orchestrating it, and he was on the FBI's most wanted list for being a violent offender for pushing signs into police lines and knocking them down. It's disgusting. Joan over on the YouTube's been a membo for 2 months. Joan, thank you for being a membo. First month's the hardest. Gets easier from there. And Wise here says a 24-hour billing is one thing, but how can a White House visit be anything but inappropriate coordination of the persecution and prosecution of a political opponent? Any other DA could use the excuse it was broad policy, but Wade has only one purpose, which is to prosecute Trump. Yeah, Knox is here. Knox is the defense lawyer in the great state of Texas. Says, yes, us court-appointed defense attorneys do not usually make $1 million a year. Jeez. Yeah. Yeah, I know. Not even close. Okay. Not even anything close to that. So it's shocking that a dude with no experience at all is making $1 million a year and then going on vacay with his Fani. Yikes. Hey, this one from Knox says, thank you everyone again for all the lovely wishes on my dad's birthday. And that was Knox this morning. Knox shared a beautiful picture of her dad. May he rest in peace. It is his birthday today. And dad was holding up a Lil Knox Bierman for all of us to see. It's a beautiful picture. So happy birthday to Knox's dad up above. Facts Matters here says Fanny's fat tab for getting tapped. Boom. From Facts Matter, 16 months. Yeah, Fanny's got a big fat tab from getting tapped. Yeah, from getting indicted by Nathan Wade. 16 months as a membo. We're almost to 2 babies. Good to see you, Facts Matter. We got Knox says, you know, you have to admit, being Fanny's beach muffin is a dirty job. The dude earned that money. Ah! Yeah, it's true. It's like, how much would you have to be paid, man? Yeah, $1 million's not enough. It's not enough. We need a lot more than that. We got Knox says, so, okay, they decide to commit graft in the highest profile case since Sacco Vanzetti. Such silly people. It's like, did they think no one was going to look into this case? It's like a national case. Like, no one's going to know, okay? No one's going to know. Just come into my office real quick. Give me a smooch. Amazing. We got Glocky McGlockface says, in 2016, with Trump's election, he made the feds and the media and the GOP and the DNC show just how corrupt and treasonous they actually are. In 2024, Trump is exposing the judiciary system and the DAs and how corrupt and slimy and criminal they are. It's a good comment. Yeah, he runs, we start to see all the gears, all the facade drips off, and we get to see the people behind the curtains. Good comment, Glocky. JB's here, says the sheer amount of crimes that committed to make Trump out to be this big criminal is comical and absolutely horrifying. $100 says they get no real punishment. It's probably a safe bet. What's Judge McAfee? I got to tell you, Judge McAfee is probably just like, I cannot wait to read Fani's response. It's going to be so fun. Knox is here, says Ashley Merchant is on fire. A friend of mine knows her and she is that good for real. That's amazing. Okay, so the defense attorney community is actually pretty small. Like we all go, not me so much anymore, but like everybody goes to the same DUI defense conferences and stuff like that. I'll go down, a bunch of DUI lawyers studying DUI law, getting hammered. It's actually a good time. So, yeah, I believe it. I believe she's awesome. And it was a great motion. And she's got some cojones to file that. Like a lot of other attorneys out there, you may not file it. Like, this is a little too hot for me. How can I prove this? It's going to bring down all the pressure on me. A lot of attorneys out there, are unfortunately paper pushers. A lot of them are not, but a lot of them are. Like we used to call them the see 'em and plea 'em type. Oh, we just see 'em and plea 'em. Come on in, plea 'em out. I'm like, oh, can't stand that. This old guy is here, says Wade couldn't afford the PP breaks. If you take a PP break, it costs you $62.50 per P. It's not worth it. He's just holding it in, man. Although that's not good for his kidneys. He's going to have to probably, deal with that later on in life. We'll see. Good to see you, this old guy. Spud says, it looks like Nathan will need a new chess clock for doing billable hours. A new little, slap the clock on there. Good to see you, Spuds. Crash says, it's not Willis and Wade I want to hear from. It's Wade's former business partner. Wonder if he has a conscience and wants to keep his reputation, or if he is as corrupt as the Wade-Willis duo. Surely he has the raw info on Wade getting the special prosecutor gig from Big Fani. Yeah, I think that that's a good point. Now, again, I think, he might just want to get out of the blast zone. Like, I wouldn't really blame him for wanting to get out of the blast zone, but maybe we'll get more from him. Dolphin Fan is the man, bringing in new membos. We've got 5 membos coming in courtesy of Dolphin, including Glenn C., Tammy, John O., James B., and Bullwinkle Sprinkles. Thanks to Dolphin Fan is the man in the house. Glocky McGlockface says, okay, so either she lied under oath, which is a felony, or someone changed her testimony, talking about Cassidy, on official transcripts, which is also a felony, or it's a combination of both so she can grift, and the J6 committee gave all of these people promises that the DOJ wouldn't go after them if they lied, because you live in a fascist country. From Glocky McGlockface, if they can't find actual evidence, they just make it up. This old guy says, I'm pretty convinced that Hutchinson wasn't lying on her original deposition, but she sure became a liar when she signed that errata sheet. And I think that's a really great point, this old guy. She was it sounded like actually kind of truthful. Didn't know much. Just made up stuff. He was in the beast or whatever. But that's the point. It's like your statements are unreliable. So they whitewashed the whole thing so that they could parade her in front of the rest of us. This one from Jay Water, said the road less wolf, says, what are the chances the judges consider Epps' probation as time already served? It's a good question. Probably unlikely. The legal answer is unlikely, but he's not going to have to do anything. He'll just be on probation and the whole thing will go away. So not much of, well, it's not going to go away, but he'll be done. He'll have a misdemeanor, no jail time, no prison time, and do some community service, pay some fees, and that's it. Glocky says, Rob, we sent a couple million young men across the ocean to end a regime like this, but no one is coming to save America. And foreign nations are joining the fascist Democrats in destroying America and cheering on its destruction. There is no opposition party. We are on our own. I totally believe that. I think that that's a big impetus for why I want to build a community, why I want to build the Watcher Lodge. It's so that we have connections, so that our informational supply chains are stronger, because there is nobody coming to save us. It is up to us at this moment. So I totally agree with you, Glocky. It's a sad state of affairs, but we are Americans, and so we're going to figure it out, and we're going to be better off for it. Glocky says, when the weird kid invites himself to eat lunch at the cool kids table, everyone looks at him like, what are you doing, weirdo? Glocky says, it's time for all the red state AGs to do a Nuremberg Part 2, hold trials on all these fascist Democrat judges, because we all know the cowardly Republicans in the House won't do it. George is here, says, I thought threatening a president was illegal. Upside down world. Well, you can kind of do whatever you want against Trump because, it's just Trump and the rules don't apply. We've got Sportfish says, another awesome show, Rob. We appreciate the hard work you do put into keeping us informed. Well, thank you, Sportfish. I try to deliver good shows. I put a lot of work into it. I try to make it good and flow and have a little fun, make it educational. So thanks for saying that. And honestly, thanks for watching and thank you for the support. Thanks for being a membo on Rumble. I really couldn't do the show without you. So thank you for saying that and for supporting us. Glocky says, President Obama literally ordered a drone strike on an American teenager in a cafe in a war we aren't even at war with. And I'm guessing these 3 judges who look like they smell bad would be like, oh, glorious Obama. Oh, dear leader, you're immune. No doubt about that. It's Trump. They're wrecking the system because of Trump. Dapper Dave says, the judges sounded more like Democrat Congress members at a committee hearing looking for gotcha moments rather than a sincere review of the case, which is honestly why I didn't play any of the other side. Actually, I just kind of played this because the judges were doing the questioning themselves. And it was a pretty short hearing, just like an hour, I think. Tara says, I emailed you an X post from today. It's terrifying. Uh-oh. All right, Tara. I'm sure it's in my inbox. I'll take a look at it. Thanks for sending that over and for the dono. Air Force vet says Ray Epps is a Fed. And I don't, I would say there's something going on there. He's an undercover person. He's a collaborator. He's a contributor. He's something, but he's not an innocent J6er. Air Force vet this morning sent this one in. Thank you, K-Bean. We were talking about immigration. Air Force vet said, I agree legally, but Biden screwed that all up now. The world is in chaos because of Biden. The USA is the safest country in the world, even if it has problems. Yeah, I think, America is kind of the last line, which is why my plan is to stay here and to fight for it peacefully. We got Tree Bark says, great show as always, Rob. Wouldn't it be great if Fani used some federal money to pay Wade and Jim Jordan and the boys found it on the audit of the books? He has been asking what she has been doing with the money. I don't know who cracked the code, whether it was Ashley or whether, think about this. There's 4 other people who took plea deals. They're probably regretting that if this case gets dismissed. Hey, betrayed by corrupt scumbags. Been a membo for 13 months. That's a baby and then some. Says, stay safe, folks. Totally amazing advice from betrayed by corrupt scumbags. Pinochet's helicopter tour says Epps is going to be looking over his shoulder from now on. And he'll probably get, a multi-million-dollar settlement from Fox, and then he'll go hang out, I don't know, wherever Liz Cheney lives, and Jen Psaki and the rest of them. Kelly says, the best way to tell Cassidy is lying is how she speaks. She talks so softly, like she's afraid of the words coming out of her mouth. And I think Cassidy's, a troubled person. I think that she was probably on, the right side before she got freaked out, joined the left side, probably just a fair weather witness, honestly, which is totally unreliable. And it should have been called out appropriately as such. So yeah, I don't think she's credible at all. CF Rob says, over on Rumble, says the Secretary of State who says that they won't count Trump's ballots if he wins at the Supreme Court for insurrection if he wins, she won't count his ballots. That's mass voter fraud. Yeah, but she says it's just legal. It's just the legalities. She should just she's just following the law. That's all. Tara says my email is about Trump being unalived. Should play it. Well, let me take a look at it first, and then we'll see if we can work it in to the show tomorrow. But thank you, Tara, for sending it. And, those stories are not good. Let's say hello to our friends on X before we wrap it up and we go over to watchingthewatchers.locals.com for a very short after party. Let's see who we've got here on the X platform. Of course, 23 viewers are watching us here. We got Danny McWilliams says, if an individual in the military determines that an order is illegal, they have a duty to disobey. It's in the Uniform Code of Conduct. Fred says, imagine the corrupt crimes of Tish James, no doubt. Tim Clifford says, this is incredible, and it would end a conservative's career. Will it end hers? Feline says, I thought the Court of Appeals was going to address the amicus brief as well. They said that, but they didn't. Or am I mixing it up with the Supreme Court? I was listening for that too, Feline, and I did not hear that in today's session. So we've got, in honor of Pumpkin Marie, says Fancy goes on vacay with her special prosecutor. These judges are so corrupt and gross. I'm losing hope our legal system can be rehabilitated. Way too many Fannies out there. What's up? Says, been watching you since Chauvin. Irex says, great job. Jarbot's in the house. Very nice to see. Matt says, this is wild. They went to Disney World. How many lawyers read on the toilet and get paid for it? It's a good question. Probably a lot of them. JB says, what's in the water in Georgia? First, it's sheriffs doing things. Oh, really? And then Fanny's getting paid to take, Wade is getting paid to take Fannies to hotels. Oh, gosh. Yeah, it's just a wild scene out there in Georgia. And so, my friends, thanks for following us on X at Rob Govea ESQ. Appreciate you joining us over there, retweeting stuff, following other watchers out there in the wild. We are wrapping it up, going over to watchingthewatchers.locals.com for our after party. Come and say hello. Members on Telegram, members on YouTube, join us on Telegram. We also want to thank the mods and the meme smiths who mod down the fort for us. Our friends Vianticus Prime, K Bean, Just Cause, Playin' Hooky. We got Ronnie Cole, our friend Zulu, Beyond Jo, Zach Nichols, John Allen, Janek, Dog Digger, and Donut Mind Me, all modding down the fort for us. And thanks to Vianticus and K Bean for clipping away for us on the day. We got Sleepy Dog, Geegum Geegum, and our meme smiths, Nathan N810 in the house. But that, my friends, is it for us on the day. We are going to be back here tomorrow to get into it all again. And so I hope to see you right back here so that together, hey, Just Lucky became a member. Thank you. Just Lucky, I guess, became a supporter. Thank you for that. So that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.